welcome to Lunchtime Politics on Channels Television. I'm Kayode Kikulu in Lagos. But first, the biggest political stories of this hour. Boko Haram terrorists kill army captain and soldier in an early Wednesday morning attack in Goza, Borno State. The Nigerian army and security forces responded, killing 3 of the terrorists and recovering arms. And legal fireworks continue with the trial of IPOB leader Nnamdi Kanu at the Federal High Court Abuja, as the court admits into evidence exhibits allegedly linking him to acts of terrorism. And Senate steps in to tighten oversight in Borno State with the setting up of an 18-member committee to monitor the activities of the sole administrator. Begin with security. A midnight attack by Boko Haram terrorists on Isge community in Goza, local government area of Borno State, northeast Nigeria, which resulted in the killing of an army captain and a private soldier. According to the Emir of Goza, Mohammed Shehu Timta, the attack happened around 1 a.m. on Wednesday when the terrorists infiltrated the farming community, shooting sporadically before the personnel of the Nigerian Armed Forces, with the assistance of local hunters, vigilantes and members of the civilian JTF, neutralized the terrorists, killing 3 of them while recovering items from them. Several motorcycles, bicycles, an operational vehicle and a sophisticated rifle, all belonging to the terrorists, were recovered. Speaking to Channels Television earlier today, the traditional ruler commended the military, the men of the civilian JTF, local hunters, vigilantes, and the resilient community of Isge for their collaborative efforts in repelling the attack, while praying for the repose of the souls of the departed military personnel and their family during this irreparable loss. He also called an urgent step by the federal government to address the renewed attacks as people prepare for this year's farming season. And to the courts now, where the trial of the detained leader of the proscribed indigenous people of Biafra, IPOB, Nnamdi Kanu, continues before Justice James Omotosho of the Federal High Court, Abuja, with the prosecution tendering key exhibits linking the defendants to acts of terrorism. Led in evidence by the prosecuting counsel and senior advocate of Nigeria, Adigboyega Awomolo, the prosecution's witness, with codename Triple B, resumed testimony focusing on a petition allegedly authorized or authored by the former Attorney General of the Federation, Abubakar Malami, and addressed to the Department of State Services, DSS. The letter accused Kanu of terrorism, murder, and incitement to violence against Nigerian security agencies. The document, dated June the 17th, 2021, was admitted into evidence and marked as Exhibit PWF, following no objection by the defense team led by Kanu Agabi, senior advocate of Nigeria. The witness read from the petition, which alleged that Mr. Kanu, through various broadcasts, incited attacks on police and military personnel, resulting in killings, arson, and the destruction of public institutions, including police stations and correctional centers. According to the witness, he instructed through his broadcast that police and army should be brought down and their guns seized and used. The petition also cited a series of violent incidents attributed to the IPOB leader's directives, stating they constituted a serious threat to national security. The court also admitted Kanu's written statement to the DSS dated July the 17th, 2021, in which he declined to make a fresh written submission, stating he had already said all he needed to about the allegations.
The trial of the leader of the indigenous people of Biafra, Nnamdi Kanu, resumes at the Federal High Court Abuja, with both parties ready for the day's proceeding.
How are you?
Mr. Kanu arrives and exchanges pleasantries with his loved ones and legal team.
Hold on. How are you?
At the resumed hearing, the trial continued with the cross-examination of the first prosecution witness, identified as AAA. The witness said he is not aware that the defendant was charged with 15 counts, but that he is aware that Kanu was charged with inciting others to attack members of the police force. Re-examined by lead prosecutor Adegboyega Awomolo, the witness stated that Kanu's activities amounted to agitation for the secession of parts of Nigeria. The second prosecution witness, identified as BBB, an officer with the DSS, testified that he was assigned by the Attorney General of the Federation to investigate Kanu. He described the defendant as the operator of Radio Biafra, which he said operated illegally, and the founder of the Eastern Security Network. Attempts by the prosecution to tender a letter authorizing the witness investigation was resisted by Mr. Gabi, who objected on the grounds that the document was not front-loaded. The prosecution later withdrew the document and the court granted the withdrawal. The trial also saw disagreements over the admissibility of video evidence presented to the defense. The court ordered that all materials intended for trial must be served in advance and listed properly, stressing that no document will be admitted unless previously disclosed to the defense. On a separate issue, the prosecution said it had filed a motion for the release of certain items already tendered as exhibits, specifically items numbered 1 to 28 and 30 to 39. The court directed that the motion must be refiled, with each exhibit identified and properly referenced. Earlier, Justice Omotosho issued an order barring a sister-in-law to the defendant, Mrs. Favour Kanu, from attending the next 3 court proceedings. The decision of the judge was informed by the conduct of the lady, who engaged in live broadcasts of the court proceedings on her social media platform.
The prosecution realized that they couldn't go on because the documents they wanted to rely on were not served on the defense. And indeed, the court doesn't even have copy. So the court agreed to their suggested adjournment for tomorrow so that the documents will be served on the defense.
Justice James Omotosho subsequently adjourned the case to May 7th for continuation of trial of the second witness. Emanuela Ekele, Channels Television News.
And now to the National Assembly, where the Senate has stepped in to tighten oversight in Rivers State. An 18-member committee chaired by Senate Leader Okpeyemi Bamidele has been set up to monitor the sole administrator's activity. Senate President Godswill Akpabio, announcing the move at plenary, stressed the need for transparency, hinting that the committee's makeup could be adjusted after further consultations. Our correspondent Gloria Mezoke reports.
After about 6 weeks of recess, lawmakers in the upper chamber resumed plenary led by the President of the Senate, Senator Godswill Akpabio. As promised, the oversight of the administration of Rivers State under Vice Admiral Ibok Eteibas, retired, is prioritized on the day's agenda, and consequently a committee is set up with no less than 18 members.
Let me also mention that there is need for us to have a committee to oversight the functions of the administrator of Rivers State and the Rivers State government under emergency rule. So the chairman of that committee will be Sir Distinguished Senator Michael Okpeyemi Bamidele. So if there is need to review, it will be after further consultation with our colleagues. But in the meantime, they have to get to work immediately.
Mr. Senate President,
in a motion sponsored by Senator Jimoh Ibrahim, the persistent security challenge and the need for a national summit takes center stage.
I want to say clearly that the language relied on by the military today are outdated because criminals also learn those languages and they are using them. It is imperative that empirical fact-finding mission, National Assembly Security Summit, is organized by these senates.
Arguments on the subject matter immediately became polarized as lawmakers cautioned against the demerits of convening another security summit after previous assemblies had produced summits with failed impact.
I don't believe that having security summit is the answer. Else, what we did in the past, what happened? All the recommendations are there and they are not implemented. We should call the Chief of Army Staff, the Chief of Air Staff, the Chief of Naval Staff, the Chief of Defense Staff, and we sit with them here and discuss where is our Chicano aircraft, fighter jet. And you also recall, this Chicano was purchased by no less than $1 billion borrowed. But we can no longer use Chicano because they have signed a contract which limited the operations of this Tucano. If you know ab initio that this Tucano has limitations, I believe Security Summit is not the solution. It's much, much, much more than that.
Proponents, however, argued that fresh engagements have become imperative to support the military.
That we have provided solutions in the past and they have not worked or they have not been implemented will not stop us from providing solutions.
Those in support that the Senate should be in the forefront of convoking a national security summit, say aye. Those against say nay. The ayes have it.
By the same token, the lawmakers adopted a resolution to fast-track a bill proposing to regulate vigilante outfits and hunting activities nationwide. The proposed bill will also require hunters to report to the nearest police station when entering another state for hunting to enhance accountability and improve security.
Now, before its adjournment, the Senate has resolved to peruse over the report submitted by the Senate Committee on Finance on the 4 tax reform bills passed by the Senate in November 2024. The lawmakers are now expected to hold a robust deliberation ahead of its final passage tomorrow. From the National Assembly, Gloria Umezuke, Channel Television News.
And let's bring you news just in. The Nenadi Usman-led Labour Party Caretaker Committee has begun an investigation into Barrister Julius Abure into what it calls his deliberate refusal to stop parading himself as the national chairman of the Labour Party and using the party as there was his personal enterprise to pursue selfish ambitions. Senator Nenadi Usman, who is currently briefing the press, alleged that Barrister Abure, who should have used his office to unify the party, used it instead for personal gains and enrichment. The Caretaker Committee is urging Barrister Abure to appear before its disciplinary committee immediately to answer pressing questions on various allegations and petitions against him. The committee is to be chaired by Senator Ireti Kingibe. Well, let's bring you more stories now, but this time at the local government level, where the Senior Special Assistant to the Lagos State Governor on LSDPC matters, Darren Phillips, popularly known as Dr. Case, has declared his ambition to run for local government chairmanship of Ikoyi, Abalinde Local Council Development Area under the APC. Speaking during his declaration rally in the Abalinde area of Lagos, Mr. Oshodi explained that he has learned the rudiments of leadership for over 2 decades and is ready to engage the people through digital centers and employment.
We need the best of the best in the race. There's nobody else that's going to fix our community apart from us. And if you have people of substance, people who have trained for this position, people who have worked, have been exposed to all different facets of business, whether from entertainment to agribusiness to real estate, who have, an insight that is a bit higher and a bit more worthy of such an important LCD. What they should be expecting is dynamism, creativity, excellence, just someone who is visionary. I would say I've trained for this position for 26 years. I believe we should be doing 20-25 things in 2025. and that is mostly focused around artificial intelligence, AI. I believe there's an unmatched potential which we have to tap into as not only Africans, but Nigerians and Lagosians, which can transform building digital centers, unique ways. That creativity that I mentioned earlier, putting it matched with AI can give ourselves employment, it can give us opportunities which we've never even dreamed of.
A total of 22 lawmakers in the Delta State House of Assembly, including the Speaker, have officially switched allegiance from the PDP to the APC as expected, and their letters confirming the move were formally submitted and read by the Speaker during plenary session. And this follows the defection of Governor Sheriff Oborowori and the entire PDP leadership in Delta State to the APC. And during plenary, a motion was moved by the House Leader and subjected to a vote before the defection was admitted. So yesterday saw its fair share of defections, official defections, both at the National Assembly and, as you can see, at the state assemblies. What do we make of all of this? Well, we're joined on the program by legal practitioner, Mr. Omar Aminu Kalgo, joins us virtually from Kebbi State. You're welcome to Lunchtime Politics, Mr. Kalgo. First, I want to get your thoughts before we get to the legal implications of the defections and all of that. I want to get your thoughts on this committee that has been set up by the Senate to oversight Rivers State, right, to basically monitor the activities of the sole administrator in Rivers State. Now, this is coming well over a month, almost 2 months after that announcement, and lots of actions have been taken by the sole administrator. Well, for some, they say this is too late in the day. But what are your thoughts? Because this is an incident you've spoken about and you've followed as well.
Yes, pertaining to the action by the Senate to set a committee over the issue of the state of emergency in Rivers State, one could say, looking at what is at stake now in Rivers State, there is a state of emergency, which signal that the situation in the state is an abnormal situation. And that's why the state of emergency is there to now bring back the River State into a normal functioning democracy with the executive and the legislature. So I would say it's just an effort by the Senate to say, because when you look at the Constitution, state of emergency is under 305, while the National Assembly can have its own way of dealing with situations where you find a state house of assembly not being functional, unable to function under Section 109. But my concern here is these two, I think they are just mutually exclusive. And what they are doing, I believe, is just an administrative measure to also key into seeing how maybe they could facilitate issues in River State. That's the way I can see it. But these two sections, I think they are mutually exclusive. So now what we have is just the state of emergency, and this committee, to the best of my understanding, is just an administrative measure on the part of the National Assembly to perform an oversight function.
So the question is, what will be the effect, the value of this committee? Would it really change anything in the whole scheme of things? That, as you said, that this is an abnormal situation. So how much normalcy or how much constitutionality can this committee prefer or basically give to this abnormal situation in that sense?
I think that it will not be easy for anyone to preempt the outcome of the workings of this committee, because after all, this committee is going to engage the sole administrator there, and also the governor and the State House of Assembly and members in particular. We know that it has a very split House of Assembly. So these workings have to do with certain actors. And the only success guaranteed for this committee is when it's, achieved forming these actors into being productive and keying in to bring about a normal situation after what we are in right now.
So doesn't this feel like an afterthought for you? Because some will say that the National Assembly had a chance to really do something different when that decision by the president was put to a vote, but it passed through. So isn't this an afterthought, too late in the day, really?
One can say it is an afterthought. I think it's understandable to say that. But what I want to highlight is that the National Assembly backed the executive in ensuring that that state of emergency was imposed. So maybe they think that at this time, maybe if they key in, maybe they could possibly limit the extension or to see that it is well contained within the first 6 months. That's one. And why I agree that it may be an afterthought is the other section I mentioned, that is section 109 of the Constitution. Even if the National Assembly, the executive have not invoked the declaration of state of emergency, the National Assembly is empowered wherever it notices that a state house of assembly of a state is unable to function. They can come under 109 and act as the house of assembly of a state to bring things to, but they have not done that. That's why I would say is one can say so, but they have not exercised that. It is the executive that initiated this under 305, which is state of emergency.
All right, and they endorsed it fully. But let's now talk about another issue which we touched on earlier on, and that's the pouring into the APC at both the state and federal level. But, you know, the Delta State case is quite curious because all of the lawmakers who are elected on the platform of the PDP poured into the APC from top to bottom in that sense. There's been that classic debate. The people gave the mandate to the PDP, right? People vote for parties, right? And then the lawmakers took that mandate and went to the APC. Maybe this is another abnormal situation for you, but from a legal perspective, is there any challenge here that you see?
You see, the politicians are exploiting what is there and what is possible under the law. The defection we talk about, you know, is dictated by what the law have stated, that under the issue of this defection, it is only either the National Assembly or the State House of Assemblies could declare defection of a member. And well, as we can see, I mean, everyone, including the press and what have you in the nation, can say that really there was a defection, which is de facto. But in law, what matters is that before you can pronounce that there is a defection, there should be a proceedings in the House, which must be with evidence that such have crossed over to another party, and now they would declare them by vote in the House that there is a defection and their seats need to be vacated. What I'm trying to say is when you have a massive move like the one we saw, they will not take this action because definitely they will not vote themselves out of offices, but they will act just to send politically the signal that they have crossed over to another party. But they will not follow through to now deprive themselves of that offices. So this is what mostly transpired in these state houses of assembly, as we see. And if you remember in the just recent judgment of the Supreme Court in the case of Rivers State House of Assembly and another, and the government of, it's come to this point where the Supreme Court clearly said that it is only the State House of Assembly or National Assembly, as the case may be, that have right to declare a seat vacant based on defection, I mean. So this is what is really transparent. They are exploiting the situation under the law and are not trying to rob themselves of their seats while they play their normal partisan politics.
So can we assume then that the people they represent are in agreement with this, or they are in on this? Because the law also gives them an opportunity to seek redress by way of recall, right? If they say, well, this mandate we've given you, you're not using it well, or you have taken it where we didn't send you, come back, let us give the mandate to someone else. But so far, we've not seen that happen. So can we also say that the people are in on this, they're in agreement, so no need splitting hairs?
Absolutely. If the opportunity is there for the electorates and no one moved to, try and recall certain, well, that silence will signify some acknowledgement. But we all know that that said, a lot of concerns are raised. Even with that, recall is not an easy thing to do. But if really the electorates are onto that, I think they can pursue it. My hope is that, as you can see, we face different challenges before in elections as they come. And I think what we need to get right as we head to 2027 mostly is this intra-party issues and also the political party crossover. I think these are some of the things that we need to fix right. And prior to the last election, some of these things which have to do with intra-party issues were legislated upon, like the level of time where somebody willing to contest should, relinquish an office and other things. So as we prepare for the election, the intra-party election, I think, is very, very significant because after all, it is after the intra-party have selected their candidates and what have you, that's when the general electorates will have, the opportunity to vote. And a lot of times people are not mostly happy with what happened intra-party. So I think this legislation and other things should be those in a way that they could help us to achieve this. And the issue of defection, if you look at it, it is not fair to all politicians because the Constitution penalize or make it possible for a member of a political party to lose his seat if he is in the legislature, while in the other part, the executive have no such provision. So these are all some of the things that I think we need to consider as we move ahead.
Well, very important points there, but it's been said time and again that it looks like the system is stacked against the average person, because for you to go through a recall process, it will cost a lot. So most people just say, you know what, it's not worth it. Let's just keep managing. But we have to thank you so much, Mr. Omar Aminu Kalgo, legal practitioner. It's been a pleasure speaking with you on the program.
My pleasure.
Well, there you have it. You've been served this afternoon on Lunchtime Politics. Thank you for watching. I'm Kayode Kikyo.